Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today we have Dore and Barreau du Quebec. I apologize in advance for any pronouncements of French I do, because they are all going to be incorrect, because I do not speak French. I first read this decision in the legal profession, and it's a very entertaining decision. Zach, do you remember reading this one?
I do. I waited to take legal profession until third year, and it was actually a really good decision. I suggest everyone take legal profession in the third year when things get hectic. But I do remember reading it, and I actually had to jog my memory a little bit on this one, but it's actually a really great case of what not to do.
Yes. I know. And it's crazy, right? Because this stuff isn't easy. I like it. I like the case because I think it reminds me sort of, the law is made of people, with emotions and feelings. And sometimes we say stuff we shouldn't, and we make snap judgments and all this stuff. And it's kind of a normal thing, right? So we sort of need mechanisms to be able to navigate what happens if and when someone, steps over a line, breaks rules of civility and that stuff. Plus, I must admit, all due respect to Justice Bollard and Mr. Dore, the letter that was written is pretty funny. It could be on, a Law and Order type show. It's pretty hilarious in retrospect to read the letter. It's very, not nice. As my niece would say, not nice. Not a nice letter.
It's always interesting. I've found that I guess my favorite thing is, life is crazier than any fiction that we could ever dream of, right? Especially when it comes to, sticking your heels in the sand, so to speak, and saying, this is my position, you've crossed the line. Yeah. Right? And that's kind of the messy thing that you learn with legal ethics. Maybe not messy isn't the right word, but the complicated aspect of legal ethics is that sometimes it's very obvious what is unethical, and other times sometimes it's not so clear. Yeah. Sometimes you need some guidance as to why what that is ethical or not.
Definitely. And the law is not, it's not like an antiseptic chamber, right? It's things are going to be a mess. I don't know. I don't think it's weird to call it a mess because it is a mess. This situation is kind of a mess. And it's the court does their absolute best to, unpack it, break it down, discuss what happened, go through the rules. Exactly what you should do when you, face a situation where you don't know what's going on. It's you need to sort of take a step back and be able to really look at your ethical duties and obligations and figure out sort of what's what. And, I think the court does a pretty good job. It's a unanimous decision. Plus, they clarify the standard of review for Law Society disciplinary stuff, which will come up again later in another decision we've got coming up, Groya. And I don't know. I love this decision. Mainly, I don't know. I feel I keep picking decisions I like because I think they're funny. So we need to have guest readers who are more into reading serious things, because right now I'm selecting based on laughs because I adore this decision. I think it's well written. I think that they brought up a lot of good points, and I think it raises really important issues just on how messy civility and intercollegial bar stuff with the judiciary can be. This stuff isn't easy.
Yeah, and the interesting thing is, like you said, the law is made up of people. Yeah. And when you're in law school, at least I found, it can feel very sanitized, right?
Yes.
You refer to cases by case names, and it's almost like you forget that there's either one or two people involved in this, right? One person if it's criminal, two people if it's anything else. Yeah. And the other thing, too, I want to hit on is civility is so contextual and so subjectively driven based on, the community you come from.
Yep.
And one of the things that you need to almost unlearn is what you consider to be rude at times might just be another person's learned civility. Yeah. Right? Not everyone makes eye contact all the time.
Yeah. No, definitely. Right? Yeah. It's definitely going to depend on, where you're coming from. And so that's almost why soft skills, social interaction skills they're crucial. They really are, because it's if you don't know how to sort of read what's happening in a situation, you might read someone as being very rude when that is completely not their intention and they are not at all trying to be rude to you. But like if you can't sort of contextually read because you haven't built up your soft skills, it can be hard. And I don't know, I'm always going to go with the funny stuff, but this is definitely an interesting decision in terms of like legal ethics and professionalism.
Yeah, I love the funny cases. Like I said, like life is stranger than fiction. And I guess just everyone, let's just work on our soft skills and, don't be afraid to engage with material that, you need to learn about. Because law, ultimately, it's a social job.
Exactly. We are, for better or worse, in the people business. Hope you guys enjoy. Dore and Barreau du Quebec. On appeal from the Court of Appeal for Quebec. The judgment of the court was delivered by Justice Abella. The focus of this appeal is on the decision of a disciplinary body to reprimand a lawyer for the content of a letter he wrote to a judge after a court proceeding. The lawyer does not challenge the constitutionality of the provision in the Code of Ethics under which he was reprimanded. Nor, before us, does he challenge the length of the suspension he received. What he does challenge is the constitutionality of the decision itself, claiming that it violates his freedom of expression under the Canadian Charter of Rights and Freedoms. This raises squarely the issue of how to protect charter guarantees and the values they reflect in the context of adjudicated administrative decisions. Normally, if a discretionary administrative decision is made by an adjudicator within his or her mandate, that decision is judicially reviewed for its reasonableness. The question is whether the presence of a charter issue calls for the replacement of this administrative law framework with the Oakes test, the test traditionally used to determine whether the state has justified a law's violation of the charter as a reasonable limit under Section 1. It seems to me to be possible to reconcile the two regimes in a way that protects the integrity of each. The way to do that is to recognize that an adjudicated administrative decision is not like a law which can, theoretically, be objectively justified by the state, making the traditional Section 1 analysis an awkward fit. On whom does the onus lie, for example, to formulate and assert the pressing and substantial objective of an adjudicated decision, let alone justify it as rationally connected to, minimally impairing of, and proportional to that objective? On the other hand, the protection of charter guarantees is a fundamental and pervasive obligation, no matter which adjudicative forum is applying it. How then do we ensure this rigorous charter protection, while at the same time recognizing that the assessment must necessarily be adjusted to fit the contours of what is being assessed and by whom? We do it by recognizing that while a formulaic application of the Oakes test may not be workable in the context of an adjudicated decision, distilling its essence works the same justifactory muscles, balance and proportionality. I see nothing in the administrative law approach which is inherently inconsistent with the strong charter protection, meaning its guarantees and values, we expect from an Oakes analysis. The notion of deference in administrative law should no more be a barrier to effective charter protection than the margin of appreciation is when we apply a full Section 1 analysis. In assessing whether a law violates the charter, we are balancing the government's pressing and substantial objectives against the extent to which they interfere with the charter right at issue. If the law interferes with the right no more than is reasonably necessary to achieve the objectives, it will be found to be proportionate and, therefore, a reasonable limit under Section 1. In assessing whether an adjudicated decision violates the charter, however, we are engaged in balancing somewhat different but related considerations, namely, has the decision maker disproportionately, and therefore unreasonably, limited a charter right? In both cases, we are looking for whether there is an appropriate balance between rights and objectives, and the purpose of both exercises is to ensure that the rights at issue are not unreasonably limited. As this court has noted, most recently in Catalyst Paper Corporation and North Cowichan District, the nature of the reasonableness analysis is always contingent on its context. In the charter context, the reasonableness analysis is one that centers on proportionality, that is, on ensuring that the decision interferes with the relevant charter guarantee no more than is necessary given the statutory objectives. If the decision is disproportionately impairing on the guarantee, it is unreasonable. If, on the other hand, it reflects a proper balance of the mandate with charter protection, it is a reasonable one. In this case, the Discipline Committee's decision to reprimand the lawyer reflected a proportionate balancing of its public mandate to ensure that lawyers behave with, quote, objectivity, moderation, and dignity, end quote, with the lawyer's expressive rights. It is, as a result, a reasonable one. Background. Gilles Dore was counsel for Daniel Lanthe in criminal proceedings. On June the 18th and 19th, 2001, Mr. Dore appeared before Justice Bollard in the Superior Court of Quebec, seeking a stay of proceedings or, in the alternative, the release of his client on bail. In the course of Mr. Dore's argument, Justice Bollard said about him that, quote, an insolent lawyer is rarely of use to his client, end quote. In his written reasons rejecting Mr. Dore's application on June the 21st, 2001, Justice Bollard leveled further criticism. He accused Mr. Dore of, quote, bombastic rhetoric and hyperbole, end quote, and said that the court must, quote, put aside Mr. Dore's impudence, end quote. Justice Bollard characterized Mr. Dore's request for a stay as totally ridiculous, and one of his arguments as idle quibbling. Finally, he said that, quote, fixated on or obsessed with his narrow vision of reality, which is not consistent with the facts, Mr. Dore has done nothing to help his client discharge his burden, end quote. On the 21st of June, 2001, Mr. Dore wrote a private letter to Justice Bollard stating the following. Without prejudice or admission, Sir, I have just left the court, just a few minutes ago, as you hid behind your status like a coward. You made comments about me that were both unjust and unjustified, scattering them here and there in a decision the good faith of which will most likely be argued before our Court of Appeal. Because you ducked out quickly and refused to hear me, I have chosen to write a letter as an entirely personal response to the equally personal remarks you permitted yourself to make about me. This letter, therefore, is from man to man, and is outside the ambit of my profession and your functions. If no one has ever told you the following, then it is high time someone did. Your chronic inability to master any social skills, to use an expression in English, that language you love so much, which has caused you to become pedantic, aggressive, and petty in your daily life, makes no difference to me. After all, it seems to suit you well. Your deliberate expression of these character traits while exercising your judicial functions, however, and your having made them your trademark concern me a great deal, and I feel that it is appropriate to tell you. Your legal knowledge, which appears to have earned the approval of a certain number of your colleagues, is far from sufficient to make you the person you could or should be professionally. Your determination to obliterate any humility from your judicial position, your essentially non-existent listening skills, and your propensity to use your court where you lack the courage to hear opinions contrary to your own, to launch ugly, vulgar, and mean personal attacks, not only confirms that you are as loathsome as suspected, but also casts shame on you as a judge, the most extraordinarily important function that was entrusted to you. I would have very much liked to say this to your face, but I highly doubt that, given your arrogance, you are able to face your detractors without hiding behind your judicial position. Worst of all, you possess the most appalling of all defects for a man in your position. You are fundamentally unjust. I doubt that will ever change. Sincerely, Gilles Dore. P.S. As this letter is purely personal, I see no need to distribute it. The next day, June 22, 2001, Mr. Dore wrote to Chief Justice Lise Lemieux with a copy to Justice Bollard. He made it clear that he was not filing a complaint with her against Justice Bollard. Instead, Mr. Dore respectfully requested that he not be required to appear before Justice Bollard in the future, since he was concerned that he could not properly represent his clients before him. On July 10, 2001, Mr. Dore complained to the Canadian Judicial Council about Justice Bollard's conduct. On July 13, 2001, Chief Justice Lemieux sent a copy of the letter Mr. Dore had sent to Justice Bollard to the Syndic de Barreau, the body that disciplines lawyers in Quebec. In March 2002, the Assistant Syndic filed a complaint against Mr. Dore based on his letter to Justice Bollard. The complaint alleged that Mr. Dore had violated both Article 2.03 of the Code of Ethics of Advocates and Mr. Dore's oath of office. Article 2.03 stated, quote, "The conduct of an advocate must bear the stamp of objectivity, moderation, and dignity," end quote. In the interval between the filing of the Assistant Syndic's complaint against Mr. Dore and the actual proceedings against him, a committee of judges appointed by the Judicial Council to look into Mr. Dore's complaint communicated its conclusions to Mr. Dore and Justice Bollard in letters sent on July 15, 2002. The committee found that Justice Bollard had made, quote, "unjustified derogatory remarks to Mr. Dore." They stated in part, quote, "to use words like bombastic rhetoric and hyperbole and impudence in referring to counsel arguing a case before you, quite clearly in good faith, is unnecessarily insulting. To reply to counsel who submits that you have not allowed him to argue his case, that an insolent lawyer is rarely of use to his client, not only is unjustified in the circumstances, but could tarnish counsel's professional reputation in the eyes of his client, his peers, and the public. To say to counsel arguing a case before you that I have the impression this is going to be tiresome is to gratuitously degrade him. To describe a procedure before the court as totally ridiculous is unnecessarily humiliating. It is the panel's opinion that such comments would seem to show contempt for counsel not only as an individual, but also as a professional. The evidence reveals a flagrant lack of respect for an officer of the court, namely Mr. Dore, who was nevertheless at all times respectful to the court. The evidence also shows signs of impatience on your part that are surprising in light of every judge's duty to listen calmly to the parties and to counsel. It is the panel's opinion that in so abusing your power as a judge, you not only tarnished your image as a dispenser of justice, but also undermine the judiciary, the image of which has unfortunately been diminished. The panel reminds you that your independence and your authority as a judge do not exempt you from respecting the dignity of every individual who argues a case before you. Dispensing justice while gratuitously insulting counsel is benefiting neither for the judge nor for the judiciary. Having also read the judgments of the Quebec Court of Appeal in the Queen in Preux, the Queen in Bisson, and the Queen in Calotia, the panel observed that you tend to use your platform to unjustly denigrate counsel appearing before you. The transcript of the hearing of April 9, 2002, in Sa Majesté la Reine and Sébastien Beauchamp, which contains evidence of personal attacks on another lawyer, also confirmed that the case raised in Mr. Dore's complaint is neither unique nor isolated, but shows that extreme conduct and comments seem to form part of a more generalized attitude. In the panel's view, the fact that such an attitude could persist despite warnings from the Court of Appeal is troubling. The panel finds the impatience you showed and the immoderate comments you made to an officer of the court, Mr. Dore, are unacceptable and merit an expression of the panel's disapproval under subsection 55(2) of the Canadian Judicial Council bylaws. The panel notes that you have deferred to its decision and assumes that the fact that Mr. Dore has made a complaint will lead you to reflect on this and will remind you of your duty as a judge to show respect and courtesy to all counsel who appear before you." End quote. On July 22, 2002, after receiving this reprimand, Justice Bollard recused himself from a complex criminal trial involving the Hells Angels, a trial related to the trial of Daniel Lanthe in which Mr. Dore had acted. As a result of this recusal, the Attorney General of Quebec requested the Canadian Judicial Council to conduct an inquiry. The Judicial Council concluded that Justice Bollard's recusal had not constituted misconduct. As for Mr. Dore, the proceedings before the Disciplinary Council of the Barreau de Quebec took place between April 2003 and January 2006. In its January 18, 2006 decision, the Disciplinary Council found that Mr. Dore's letter was, quote, "likely to offend and is rude and insulting," end quote. It concluded that his statements had little expressive value as they were, quote, "merely opinions, perceptions, and insults," end quote. The Disciplinary Council rejected Mr. Dore's submission that his letter was private, since it was written by him as a lawyer. It also concluded that Justice Bollard's conduct could not be relied on as justification for the letter. The Disciplinary Council rejected Mr. Dore's argument that Article 2.03 violated Section 2B of the Charter. While acknowledging that the provision infringed on his freedom of expression, the Disciplinary Council found that, quote, "this is a limitation on freedom of expression that is entirely reasonable, even necessary, in the Canadian legal system, where lawyers and judges must work together in the interests of justice," end quote. Moreover, it concluded that Mr. Dore had willingly joined a profession that was subject to rules of discipline that he knew would limit his freedom of expression. While the rules may, quote, "be seen as restrictions imposed on the members of the Barreau in comparison to the freedom that may be enjoyed by other Canadian citizens, they are made in exchange for the privileges conferred on lawyers as members of an exclusive profession," end quote. On the 24th of July, 2006, based on what it found to be the seriousness of Mr. Dore's conduct and on his failure to show remorse, the same panel suspended Mr. Dore's ability to practice law for 21 days. Mr. Dore appealed the Disciplinary Council's decisions to the Tribunal des Professions on several grounds. This time, he did not challenge the constitutionality of Article 2.03. Instead, he argued that the manner in which the relevant legislation was applied by the Disciplinary Council was unconstitutional because his comments were protected by Section 2B of the Charter. The tribunal reviewed the constitutionality of the Disciplinary Council's decision on a standard of correctness, but said that a full Oakes analysis under Section 1 of the Charter was inappropriate, where a decision only applied to one person. Instead, it held that, quote, "the issue becomes one of proportionality, or, more specifically, minimal limitation of the guaranteed right," end quote. In the circumstances, the Disciplinary Council's decision to sanction Mr. Dore was found to be, quote, "minimal restriction on freedom of expression," end quote. It rejected Mr. Dore's argument that Justice Bollard's disparaging remarks justified his letter. It also rejected his argument that the letter was private, since Mr. Dore remained, quote, "an officer of the court and a lawyer," end quote, and had exceeded the objectivity, moderation, and dignity expected of him. Though it noted that the sanction imposed by the Disciplinary Council seems harsh, the tribunal held that it was not unreasonable given the gravity of Mr. Dore's conduct and his lack of remorse. On judicial review, the Superior Court of Quebec upheld the decision of the tribunal, including its view that the letter did not constitute a private act, and found the tribunal's reasoning to be unassailable. It concluded that by finding the decision to be a minimal restriction on Mr. Dore's freedom of expression, the tribunal had implicitly held that the restriction was justified in a free and democratic society. The Quebec Court of Appeal held that given the status and role of the parties, Mr. Dore could not reasonably have expected his letter to remain confidential or private. It acknowledged that the disciplinary council's decision was a breach of Section 2B, but, applying a full Section 1 analysis, it found that Mr. Dore's letter had, quote, limited importance compared to the values underlying freedom of expression, which are the pursuit of truth, participation in the community, individual self-fulfillment, and human flourishing, end quote. The court held that protecting the public was an important objective, and that the disciplinary council's decision had a rational connection with that objective, especially given the importance of a judge's position in the judicial system. On minimum impairment, assessing both the decision and the sanction, the Court of Appeal held that while the sanction was significant, it was targeted at the manner in which Mr. Dore criticized Justice Bola and did not prohibit the expression itself. It concluded by finding that the effects of the decision were proportionate to its objectives. Analysis. Mr. Dore's arguments rest on his assertion that the finding of a breach of the Code of Ethics violates the expressive rights protected by Section 2B of the Charter. Because the 21-day suspension had already been served when he was before the Court of Appeal, he did not appeal the penalty. The reasonableness of its length, therefore, is not before us. It is clear from the decisions of the tribunal and the reviewing courts in this case that there is some confusion about the appropriate framework to be applied in reviewing administrative decisions for compliance with Charter values. Some courts have used the same Section 1 Oakes analysis used for determining whether a law complies with the Charter. Others have used a classic judicial review approach. It goes without saying that administrative decision makers must act consistently with the values underlying the grant of discretion, including Charter values. The question, then, is what framework should be used to scrutinize how those values are applied. In Slate Communications Incorporated and Davidson, Justice Lemaire, in his concurring reasons, said that the Charter applied to a labor adjudicator's decision and used the Section 1 framework developed in the Queen and Oakes to determine if the decision complied with the Charter. Writing for the majority, Chief Justice Dixon agreed with Justice Lemaire that the Charter applied to administrative decision-making. But while he applied the Oakes framework, he notably and presciently observed that, quote, the precise relationship between the traditional standard of administrative law review of patent unreasonableness and the new constitutional standard of review will be worked out in future cases, end quote. Yet the approach taken in Slate can only be properly understood in its context. Importantly, when Justice Lemaire held that discretionary administrative decisions implicating Charter values should be reviewed under the Oakes analysis, he did so in the context of the perceived inability of administrative law to deal with Charter infringements and the exercise of discretion. This concern permeates the reasons in Slate. As Professor Genevieve Cartier has noted, quote, while Justice Lemaire thought the administrative law standard was ill-suited to Charter challenges because of its inability to inquire into the substance of discretionary decisions, Chief Justice Dixon thought it was ill-suited because of its inability to properly unravel the value inquiries involved in any Charter litigation. The approach taken in Slate attracted academic concern from administrative law scholars. Professor John Evans argued that if courts were too quick to bypass administrative law in favor of the Charter, quote, a rich source of thought and experience about law and government will be overlooked or lost altogether. Similarly, Professor Cartier suggested that the Slate approach reduced the role of administrative law to the, quote, formal determination of jurisdiction on the basis of statutory interpretation, end quote, which prevented the control of discretion with reference to values and presented, quote, an impoverished picture of administrative law, end quote. The scope of the review of discretionary administrative decisions that provided the backdrop for the decision in Slate was altered by this court's decision in Baker in Canada, Minister of Citizenship and Immigration. In that case, Justice Larray Dubé concluded that administrative decision-makers were required to take into account fundamental Canadian values, including those in the Charter, when exercising their discretion. Building on the decision in Canadian Union of Public Employees Local 963 and New Brunswick Liquor Corporation, Baker represented a further shift away from the Diceian principles. By recognizing that administrative decision makers are both bound by fundamental values and empowered to adjudicate them, Baker ceded interpretive authority on those issues to those decision makers. This allows the Charter to nurture administrative law by emphasizing that Charter values infuse the inquiry. When this is weighed together with the Court's subsequent decisions, we see a completely revised relationship between the Charter, the courts, and administrative law than the one first encountered in Slate. In Dunsmuir and New Brunswick, the Court held that judicial review should be guided by a policy of deference, justified on the basis of legislative intent, respect for the specialized expertise of administrative decision makers, and recognition that courts do not have a monopoly on adjudication in the administrative state. And in the Queen and Conway, building on the development of the jurisprudence, the Court found that administrative tribunals with the power to decide questions of law have the authority to apply the Charter and grant Charter remedies that are linked to the matters properly before them. But, as predicted by Chief Justice Dickson, this Court has explored different ways to review the constitutionality of administrative decisions, vacillating between the values-based approach in Baker and the more formalistic template in Slate. Other cases, and particularly recently, have instead applied an administrative law judicial review analysis in assessing whether the decision-maker took sufficient account of Charter values. The last decision of this Court to use the full Section 1 Oakes approach to determine whether the exercise of statutory discretion complied with the Charter was in Multany. The academic commentary that followed was consistently critical. In brief, it generally argued that the use of a strict Section 1 analysis reduced administrative law to having a formal role in controlling the exercise of discretion. Since then, and largely as a result of the revised administrative law template found in Dunsmuir, this Court appears to have moved away from Multany, leading to the suggestion that it may have, quote, decided to start from ground zero, building coherence in public law, end quote. Today, the Court has two options for reviewing discretionary administrative decisions that implicate Charter values. The first is to adopt an Oakes framework, developed for reviewing laws for compliance with the Constitution. This undoubtedly protects Charter rights, but it does so at the risk of undermining a more robust conception of administrative law. In the words of Professor Evans, if administrative law is bypassed for the Charter, quote, a rich source of thought and experience about law and government will be overlooked, end quote. The alternative is for the Court to embrace a richer conception of administrative law, under which discretion is exercised, quote, in light of constitutional guarantees and the values they reflect, end quote. Under this approach, it is unnecessary to retreat to a Section 1 Oakes analysis in order to protect Charter values. Rather, administrative decisions are always required to consider fundamental values. The Charter simply acts as a, quote, reminder that some values are clearly fundamental and cannot be violated lightly, end quote. The administrative law approach also recognizes the legitimacy that this Court has given to administrative decision-making in cases such as Dunsmuir and Conway. These cases emphasize that administrative bodies are empowered and indeed required to consider Charter values within their scope of expertise. Integrating Charter values into the administrative approach and recognizing the expertise of these decision-makers opens, quote, an institutional dialogue about the appropriate use and control of discretion rather than older command and control relationship, end quote. As explained by Chief Justice McLaughlin in Alberta and Hutter and Brethren of Wilson Colony, the approach used when reviewing the constitutionality of a law should be distinguished from the approach used for reviewing an administrative decision that is said to violate the rights of a particular individual. When Charter values are applied to an individual administrative decision, they are being applied in relation to a particular set of facts. Dunsmuir tells us this should attract deference. When a particular law is being assessed for charter compliance, on the other hand, we are dealing with principles of general application. The more flexible administrative approach to balancing charter values is also more consistent with the nature of discretionary decision-making. Some of the aspects of Oak's test are, in any event, poorly suited to the review of discretionary decisions, whether of judges or of administrative decision-makers. For instance, the requirement under Section 1 that a limit be prescribed by law has been held by this court to apply to norms where, quote, their adoption is authorized by statute, they are binding rules of general application, and they are sufficiently accessible and precise to those to whom they apply, end quote. Moreover, when exercising discretion under a provision or statutory scheme whose constitutionality is not impugned, it is conceptually difficult to see what the pressing and substantial objective of a decision is, or who would have the burden of defining and defending it. This court has already recognized the difficulty of applying the Oakes framework beyond the context of reviewing a law or other rule of general application. This has been the case in applying charter values to the common law, quote, where there is no specific enactment that can be examined in terms of objective, rational connection, least dramatic means, and proportionate effect, end quote. In the Queen and Davio, for example, in assessing common law rule relating to establishing intent under extreme intoxication, the court held that no Oakes analysis was required when reviewing a common law rule for compliance with charter values. In Hill and Church of Scientology of Toronto, this court explicitly rejected the use of the Section 1 Oakes framework in developing the common law of defamation for two reasons. First, when interpreting a common law rule, there is no violation of a charter right, but a conflict between principles, so the balancing must be more flexible than the traditional Section 1 analysis, with charter values providing guidelines for any modification to the common law. Second, the court noted that, quote, the division of onus which normally operates in a charter challenge, end quote, was not appropriate for private litigation under the common law, as the party seeking to change the common law should not be allowed to benefit from a reverse onus. As a result, the court went on to consider the common law of defamation in light of the values underlying the charter. And in Grant and Torstar Corporation, the court relied on charter values in introducing the new defense of responsible communication on matters of public interest to the law of defamation without engaging an Oakes analysis. A further example is found in RWDSU Local 558 and Pepsi Cola Canada Beverages West Limited, where the court dealt with the common law of secondary picketing. After concluding that freedom of expression was engaged, the court did not embark on an Oakes analysis. Instead, it found that the appropriate question was, quote, which approach to regulating secondary picketing best balances the interests at stake in a way that conforms to the fundamental values reflected in the charter, end quote. Though each of these cases engaged charter values, the court did not see the Oakes test as the vehicle for balancing whether those values were taken into sufficient account. The same is true, it seems to me, in the administrative law context, where decision makers are called upon to exercise their statutory discretion in accordance with charter protections. What is the impact of this approach on the standard of review that applies when assessing the compliance of an administrative decision with charter values? There is no doubt that when a tribunal is determining the constitutionality of law, the standard of review is correctness. It is not at all clear to me, however, based on this court's jurisprudence, that correctness should be used to determine whether an administrative decision maker has taken sufficient account of charter values in making a discretionary decision. The court elaborated on the applicable standard of review to legal disciplinary panels in the pre-Dunsmuir decision of the Law Society of New Brunswick and Ryan, where Justice Iacobucci adopted a reasonableness standard in reviewing sanction imposed for professional misconduct. It seems to me that applying the Dunsmuir principle results in reasonableness remaining the applicable review standard for disciplinary panels. The issue then is whether the standard should be different when what is assessed is the disciplinary body's application of charter protections in the exercise of its discretion. In my view, the fact that charter interests are implicated does not argue for a different standard. The starting point is the expertise of the tribunal in connection with their home statutes. Citing Professor David Mullen, Dunsmuir confirmed the importance of recognizing that, quote, those working day to day in the implementation of frequently complex administrative schemes have or will develop a considerable degree of expertise or field sensitivity to the imperative and nuances of the legislative regime, end quote. And, as Professor Evans has noted, the, quote, reasons for judicial restraint in reviewing agencies' decisions on matters in which their expertise is relevant do not lose their cogency simply because the question and issue also has a constitutional dimension, end quote. An administrative decision maker exercising a discretionary power under his or her home statute has, by virtue of expertise and specialization, particular familiarity with the competing considerations at play in weighing charter values. As the court explained in Douglas Quanton Faculty Association and Douglas College, adopting the observations of Professor Daniel Pinard, quote, administrative tribunals have the skills, expertise, and knowledge in a particular area which can, with advantage, be used to ensure the primacy of the Constitution. Their privileged situation as regards to the appreciation of the relevant facts enables them to develop a functional approach to rights and freedoms as well as to general constitutional precepts, end quote. This case, among others, reflected the increasing recognition by this court of the distinct advantage that administrative bodies have in applying the Charter to a specific set of facts and in the context of their enabling legislation. As Justice Major noted in dissent in Mooring in Canada National Parole Board, tailoring the Charter to a specific situation, quote, is more suited to a tribunal's special role in determining rights on a case-by-case basis in the tribunal's area of expertise, end quote. These principles led the court to apply a reasonableness standard in Chamberlain, where Chief Justice McLaughlin found that a school board had acted unreasonably in refusing to approve the use of books depicting same-sex parented families. She held that the board had failed to respect, quote, the values of accommodation, tolerance, and respect for diversity, end quote, which were incorporated into its enabling legislation and, quote, reflected in our Constitution's commitment to equality and minority rights, end quote. Similarly, in Pinay, Justice Binney used a reasonableness standard to review, for compliance with Section 7 of the Charter, a decision of the Ontario Review Board to return the appellant to a maximum security hospital, observing that a reasonableness review best reflected, quote, the expertise of the members appointed to review boards, end quote. The purpose of the exercise was to determine whether the decision was, quote, the least onerous and least restrictive, quote, of the liberty interests of the appellant, while considering, quote, public safety, the mental condition, and other needs of the individual concerned, and his or her potential reintegration into society, end quote. In Pinay, the test was laid out in the statute, but Justice Binney made it clear that the emphasis on the least infringing decision was a constitutional requirement. In Lake, when the court was reviewing the minister's decision to surrender a Canadian citizen for extradition implicating Section 6.1 and 7 of the Charter, the court again applied a reasonableness standard. Justice LaBelle held that deference is owed to the minister's decision, as the minister is closer to the relevant facts required to balance competing considerations and benefits from expertise. The alternative, adopting a correctness review in every case that implicates charter values, will, as Professor Mullen noted, essentially lead to courts retrying a range of administrative decisions that would otherwise be subjected to a reasonableness standard. So our choice is between saying that every time a party argues that charter values are implicated on judicial review, a reasonableness review is transformed into a correctness one, or saying that while both tribunals and courts can interpret the charter, the administrative decision maker has the necessary specialized expertise and discretionary power in the area where the charter values are being balanced. The decisions of legal disciplinary bodies offer a good example of the problem of applying a correctness review whenever charter values are implicated. Most breaches of Article 2.03 of the Code of Ethics calling for objectivity, moderation, and dignity necessarily engage the expressive rights of lawyers. That would mean that most exercises of disciplinary discretion under this provision would be transformed from the usual reasonableness review to one for correctness. Nevertheless, as Chief Justice McLaughlin noted in Catalyst, quote, reasonableness must be assessed in the context of the particular type of decision-making involved and all relevant factors. It is an essentially contextual inquiry, end quote. Deference is still justified on the basis of the decision-maker's expertise and its proximity to the facts of the case. Even when charter values are involved, the administrative decision-maker will generally be in the best position to consider the impact of the relevant charter values on the specific facts of the case. But both decision-makers and reviewing courts must remain conscious of the fundamental importance of charter values in the analysis. How, then, does an administrative decision-maker apply charter values in the exercise of statutory discretion? He or she balances the charter values with the statutory objectives. In effecting this balancing, the decision-maker should first consider the statutory objectives. In Lake, for instance, the importance of Canada's international obligations, its relationships with foreign governments, and the investigation, prosecution, and suppression of international crime justified the prima facie infringement of mobility rights under Section 6.1. In Panay, the twin goals of public safety and fair treatment grounded the assessment of whether an infringement of an individual's liberty interest was justified. Then the decision-maker should ask how the charter value at issue will best be protected in view of the statutory objectives. This is at the core of the proportionality exercise and requires the decision-maker to balance the severity of the interference of the charter protection with the statutory objectives. This is where the role of judicial review for reasonableness aligns with one applied in the Oaks context. As this court recognized in RJR MacDonald Incorporated and Canada, AG, quote, courts must accord some leeway to the legislator, end quote, in the charter balancing exercise, and the proportionality test will be satisfied if the measure, quote, falls within a range of reasonable alternatives, end quote. The same is true in the context of a review of an administrative decision for reasonableness, where the decision makers are entitled to a measure of deference so long as the decision, in the words of Dunsmuir, falls within a range of possible acceptable outcomes. On judicial review, the question becomes whether, in assessing the impact of the relevant charter protection and given the nature of the decision and the statutory and factual contexts, the decision reflects a proportionate balancing of the charter protections at play. As Justice LaBelle noted in Multani, when a court is faced with reviewing an administrative decision that implicates charter rights, quote, the issues become one of proportionality, end quote, and calls for integrating the spirit of Section 1 into judicial review. Though this judicial review is conducted within the administrative framework, there is nonetheless conceptual harmony between a reasonableness review and the Oaks framework, since both contemplate giving, quote, a margin of appreciation, end quote, or deference to administrative and legislative bodies in balancing charter values against broader objectives. If, in exercising its statutory discretion, the decision-maker has properly balanced the relevant charter value with the statutory objectives, the decision will be found to be reasonable. Application. The charter value at issue in this appeal is expression, and, specifically, how it should be applied in the context of a lawyer's professional duties. At the relevant time, Article 2.03 of the Code of Ethics stated that, quote, the conduct of an advocate must bear the stamp of objectivity, moderation, and dignity, end quote. This provision, whose constitutionality is not impugned before us, sets out a series of broad standards that are open to a wide range of interpretations. The determination of whether the actions of a lawyer violate Article 2.03 in a given case is left entirely to the disciplinary counsel's discretion. No party in this dispute challenges the importance of professional discipline to prevent incivility in the legal profession, namely, quote, potent displays of disrespect for the participants in the justice system beyond mere rudeness or discourtesy, end quote. As a result, rules similar to Article 2.03 are found in codes of ethics that govern the legal profession throughout Canada. The Canadian Bar Association's Code of Professional Conduct, for example, states that, quote, "A lawyer should be, at all times, courteous, civil, and act in good faith to the court or tribunal, and to all persons with whom the lawyer has dealings in the course of an action or proceeding," end quote. But in dealing with the appropriate boundaries of civility, the severity of the conduct must be interpreted in light of the expressive rights guaranteed by the Charter, and, in particular, the public benefit in ensuring the right of lawyers to express themselves about the justice system in general and judges in particular. In Histed and Law Society of Manitoba, where Appeal Justice Steele upheld a disciplinary decision resulting from a lawyer's criticism of a judge, the critical role played by lawyers in assuring the accountability of the judiciary was acknowledged. Proper respect for these expressive rights may involve disciplinary bodies tolerating a degree of discordant criticism. As the Ontario Court of Appeal observed in a different context in Capito, the fact that a lawyer is criticizing a judge, a tenured and independent participant in the justice system, may raise, not lower, the threshold for limiting a lawyer's expressive rights under the Charter. This does not by any means argue for an unlimited right on the part of lawyers to breach the legitimate public expectation that they will behave with civility. We are, in other words, balancing the fundamental importance of open and even forceful criticism of our public institutions with the need to ensure civility in the profession. Disciplinary bodies must therefore demonstrate that they have given due regard to the importance of the expressive rights at issue, both in light of an individual lawyer's right to expression and the public's interest in open discussion. As with all disciplinary decisions, this balancing is a fact-dependent and discretionary exercise. In this case, the 21-day suspension imposed on Mr. Dore is not before this court, since Mr. Dore did not appeal it, either in the Court of Appeal or to this court. All we have been asked to determine is whether the Disciplinary Council's conclusion that a reprimand was warranted under Article 2.03 of the Code of Ethics was a reasonable one. To make that assessment, we must consider whether this result reflects a proportionate application of the statutory mandate with Mr. Dore's expressive rights. Lawyers potentially face criticisms and pressures on a daily basis. They are expected by the public on whose behalf they serve to endure them with civility and dignity. This is not always easy when the lawyer feels he or she has been unfairly provoked, as in this case. But it is precisely when a lawyer's equilibrium is unduly tested that he or she is particularly called upon to behave with transcendent civility. On the other hand, lawyers should not be expected to behave like verbal eunuchs. They not only have a right to speak their mind freely, they arguably have a duty to do so. But they are constrained by their profession to do so with dignified restraint. A reprimand for a lawyer does not automatically flow from criticizing a judge or judicial system. As discussed, such criticism, even when it is expressed robustly, can be constructive. However, in the context of disciplinary hearings, such criticism will be measured against the public's reasonable expectations of a lawyer's professionalism. As the Disciplinary Council found, Mr. Dore's letter was outside those expectations. His displeasure with Justice Bollard was justifiable, but the extent of the response was not. The Disciplinary Committee recognized that a lawyer must have, quote, total liberty and independence in the defense of a client's rights, and has the right to respond to criticism or remarks addressed to him by a judge, end quote. A right which the council recognized, quote, can suffer no restrictions when it is a question of defending clients' rights before the court, end quote. It was also conscious of the fact that Article 2.03 may constitute a restriction on a lawyer's expressive rights. But where, as here, the judge was called loathsome, arrogant, and fundamentally unjust, and was accused by Mr. Dore of hiding behind his status like a coward, having a chronic inability to master any social skills, being pedantic, aggressive, and petty in his daily life, having obliterated any humanity from his judicial position, having non-existent listening skills, having a propensity to use his court where he lacks the courage to hear opinions contrary to his own, to launch ugly, vulgar, and mean personal attacks which not only confirms that he is as loathsome as suspected, but also casts shame on him as a judge, and being unable to face his detractors without hiding behind his judicial position, the council concluded that the generally accepted norms of moderation and dignity were overstepped. In the circumstances, the disciplinary council found that Mr. Dore's letter warranted reprimand. In light of the excessive degree of vituperation in the letter's context and tone, this conclusion cannot be said to represent an unreasonable balance of Mr. Dore's expressive rights with statutory objectives. I would dismiss the appeal.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.